Good afternoon. Our next case is In Re EHRH, and we will hear from the appellant.
Honorable Chief Justice Newby, Honorable Associate Justices, may it please the Court. My name is Mona Leipold, and I'm the counsel for New Hanover County Health and Human Services Social Services Department. Appearing also is Quentin Bird, counsel for the guardian ad litem, and attorney of record Jill Cairo, who was a trial counsel for New Hanover County Health and Human Services Social Services Department. I would ask at this time to reserve 7 minutes for rebuttal. This case comes to this court on a split decision of the Court of Appeals, wherein the court issued an opinion that is in conflict of the Supreme Court's decisions and jurisprudence. That can be addressed.
Counsel, can I get you to speak up a little bit?
Yes, sir.
Thanks.
This case is a split decision, comes out of a split decision from the Court of Appeals, wherein the court issued an opinion that is in conflict with Supreme Court decisions and jurisprudence, and that can be addressed in two main issues. The first is the Court of Appeals erring and reversing the trial court's conclusion of neglect for RH based on current circumstances of abuse of the sibling EH by failing to give due regard for established Supreme Court precedent in cases with similar facts. And secondly, that the Court of Appeals erred in considering constitutional issues that were not properly preserved, are excluded by clear language of statute, and are excluded by established Supreme Court precedent. Turning first to the issue of neglect, the sole question for reviewing courts is whether a trial court's conclusions of law are supported by adequate findings, and whether those findings in turn are supported by clear and convincing evidence. A neglected juvenile by statute is any juvenile less than 18 years of age whose parent doesn't provide proper care, supervision, or discipline, or can create or allow to be created a living environment that is injurious to the juvenile's welfare. And within that, it is relevant whether the juvenile lives in a home where another juvenile has been subjected to abuse or neglect by an adult who regularly lives in the home. The majority position indicates that the trial court's order is devoid of any evidence of neglect other than non-confessed and unexplained injuries. However, as is noted by the dissent, that contradicts the majority's position regarding reliance on abuse of a sibling for a neglect adjudication, provided that the existence and detailed findings of fact are more than sufficient to support the adjudication of neglect. The Court of Appeals misconstrued the adjudication order in this matter. We are specifically asking that this court reject the premise of throwing aside all the findings made in the abuse of EH in determining neglect of RH. It is appropriate and accepted to connect the finding of abuse of one juvenile to the risk of neglect for another. Facts that can demonstrate the injurious environment have been well set out by this court in several decisions. There's AW, JAM, AJLH, and other decisions, and specifically, DWP, and indicates that failing to acknowledge that acknowledgement of the older child's abuse or insisting that a parent did nothing wrong when the facts show that the parent is responsible for abuse, a refusal to make a realistic attempt to understand how a child was injured can help support a trial court's conclusion that neglect is likely to reoccur. Inability or unwillingness to confront the cause of the abuse prevents parents from adequately mitigating risk of further abuse or neglect.
So the way I was reading that case law, tell me if you agree with this, is that our jurisprudence does say that the mere fact that some sibling has been abused would not allow a trial court to make a finding that the other children are neglected. And specifically, you need to look at the evidence because, for example, there could be reasons why one specific child was abused that could never be attributed to the other children, and therefore they're not at any risk. And so the court does need to inquire into the question of whether there's some link there. But what our case law has held is that if the abuse of the sibling is unexplained and the parents can't give the trial court any justification for how it happened or what happened, that the court can make a finding that, well, then, it must have been the result of you, parents. And so if you can't even explain how it happened or that explain to me why it won't happen again, the other children are going to be at the same risk because I don't have any information about why it would be particular to this child. I mean, I'm adding a lot to what the case law says, but do you think that's essentially the
I think that
logic
is
of that string of
absolutely
cases?
the logic and the
So
precedent.
is this case one of those like LJH then? Can we make that
This is
leap here?
absolutely, I think the similarities between these cases and those cases is compelling, and should be considered by this court, because I do think that this is exactly like those other cases. And so, with that, again, a key factor, the inability to recognize that it was abuse, and the corresponding inability to commit to never repeating it is what creates that neglectful environment, for the other sibling. And in this particular case, the trial court did not rely solely on the fact that EH and RH, both of whom were of tender years, resided under the same roof at the same time. Indeed, the trial court found multiple additional factors before adjudicating RH neglected, any which on their own would support a neglect adjudication for RH. For example, the sole causation of every one of the observed injuries in this child was absolutely physical abuse. They were very serious injuries, and to bring the court back to where we are, this is a 3-week-old infant who's relying 100% on the care of a parent to provide all of their care, all of their safety, everything. We have a 3-week-old infant who can't roll over or crawl or do anything on its own, that has a broken arm, that has broken ribs, that was explained by experts to have been either compressed or squeezed, that has corner fractures on other bones, including the legs. And those corner fractures, that's where the end of the bone is basically broken off where the joint is. And in that, it was determined that it's virtually pathogenomic of non-accidental trauma, and the medical professional, particularly with those corner fractures, indicated that there was no instances of accidents that have ever accounted for corner fractures. So there was mountains of medical evidence to show these particular injuries, and the sole causation of that was physical abuse. And by the way, I'm referencing findings of fact 47 through 50 and finding of fact 21. The other factor is that these parents were the sole caregivers and were the source of the injury to the child. And those are findings of fact 16, 29, and 72. They were the only two care providers. We can't look to anyone else. It was the two of them. The medical professionals additionally ruled out other medical conditions that could have caused the condition. It was not a birth injury. That was findings of fact 20 and 38. They ruled out osteogenesis imperfecta, which is also known as brittle bone. They ruled out rickets. That was finding of fact 22. They ruled out blood and genetic disorders, finding of fact 23. They ruled out low vitamin D, which is finding of fact 24. They also had an absurd and impossible explanation that was given by the parents, which was this picking up, popping of the shoulder diaper change moment. And that is all explained in several findings of fact. And what the parents tried to say at that time was that the father put his hand under the child's head and put his hand under the child's, basically the bottom or back, and lifted him to move him over for a diaper change, and allegedly heard a pop.
Do you think it matters that, so in AJLH, the abused child is older than the other siblings, and the explanations that, and the abuse, the explanations the parents were giving was discipline for things that that child was doing, going to school and other things. And so you could logically assume if the parents won't acknowledge that this is wrong and they shouldn't do it again, the younger children will eventually reach the age when they're the same. But here, does it matter that it's reversed? So the abused child is much younger. So the RH will never be an infant again in this kind of vulnerable position. Does that matter?
So I would say that there's some consideration for that, but RH is 4 years old. This juvenile was 3 years old, and there was an uncontested finding of fact where the medical professionals stated that children, and especially young infants, are at risk for future harm or even death if returned to a same environment in which they sustained abuse and neglect. And I think that this trial court made a very good finding, and I know we heard earlier where we made those ultimate findings of fact. The trial court in this case made that ultimate finding of fact in determining that this child, due to his age, could also still be subject to that parental care, to that abusive type of situation and would be at an extreme level of risk. And what this court has held is that the trial court, as the finder of fact, looking and judging the credibility of the evidence, has the right to make that consideration and determine how much weight and credibility that applies to the other juvenile when determining neglect. So additionally, there was also other behavior of the parents. There was postpartum depression mentioned in paragraph finding of fact 27. The mother had a flat effect when she presented. That was finding of fact 25. And this one is very poignant to me and talks about care and supervision, not only for this child, but possibly for the other child. The father never went to the hospital, even after the fractures were found. Never went to the hospital. Also, the story sort of changed from the beginning to when the father decided to testify at trial, and he indicated that he brought this pop injury. First of all, it was excluded by the medical professionals. They said it couldn't be from normal care, which was finding of fact 58. You know, we've got a pop in the shoulder, but there's no break in the shoulder. There's break in the arm. There's breaks in the legs. There's broken ribs. He stated that he felt ill or he was sickened by this sound and wanted to take the child immediately to the hospital. But there was a 6 to 7 hour delay in treatment when the parents went instead to Walmart and to visit the family. And that's finding of fact 28. So that does directly go to appropriate care, not only for this child, but appropriate care for children in the home. Also, another finding, which goes along with the Supreme Court precedent, there was no way to experience, for this child to experience this type of trauma necessary to cause these injuries and for the parents to not be able to notice. So one of these two parents was taking care of the child, and there was no way that they would not have known that they injured this child. And I would point out the majority's own opinion with regard to RH. And it's just, I have a hard time reconciling the great portion of the opinion where they find abuse and then they completely do something separate for neglect. They said, until the perpetrator or perpetrators of EH's injuries are established, mother and father's home present a potentially injurious environment for EH. And that was at the opinion on page 15. And now the court is then asking you, after making that statement in its majority opinion, to say, it's really, really dangerous for this one child, but this child over here is okay. And that's not what the trial court found. And again, as the finder of fact, the trial court weighs that credibility of the evidence and makes the decisions. And in this case, the trial court did that appropriately. And because the trial court did that appropriately, made the appropriate findings of facts, which supported the conclusions of law, I think that this court needs to make the finding that the opinion of the Court of Appeals should be reversed. In addition, the court did make those ultimate findings regarding risk, utilizing that logical inference that the court's allowed to make to the facts set forth with regard to EH in finding of fact 71 and 72, indicating that due to his tender years, RH is at risk for being subjected to the same infliction of injuries as EH. That is supported by finding of fact 68 and finding of fact 72, that this is their home is rendered an injurious environment for any juvenile, as there are no reasonable means to protect any juvenile from a similar injury occurring in the home. And again, that goes back to the acknowledgement. At no time, even after the explanation from the medical professionals, did either of these parents acknowledge that this was abuse. So the important key factor is that acknowledgement. Secondly, the Court of Appeals, in its opinion, ignored the Supreme Court precedent that is available. The Court of Appeals failed to distinguish the Supreme Court cases and, in fact, failed to address them at all.
So if we agree with you, is the right course to remand to the Court of Appeals and force it to deal with our precedent, or for us simply to decide the matter ourselves?
So I'm going to point to AJLH for that. I think that the court has previously done that. And then the Court of Appeals thereafter said, no, with all those considerations, we still think we were right. And then it went back to the Supreme Court for AJLH2. And then this court sent it all the way back to the trial court. And I do believe that because this court has done that before, that it would be appropriate in this case to do that now. And anything else would be a delay of permanence for these juveniles.
But we have to think also though about all the other cases that are in the pipeline, and so there is some value to making the Court of Appeals do what we say.
I will say there obviously is value in that, but I'm going to say that, again, looking at AJLH, this case, AJLH was decided, well, AJLH 1, the first time it came to the Supreme Court, was decided in 2023, and this case was decided in 2024, and this court gave some very specific, and I'm sorry, I'm kind of getting into the other issue of constitutionality. This case gave some very, very specific requirements on remand in a footnote. And the court really didn't take that into account and did not follow those types, what the specific requirement was in that. And in that footnote, there was a statement, the Court of Appeals opinion discusses the respondent's constitutionally protected rights to parent their children. This court repeatedly has held that this constitutional issue cannot be addressed on appeal unless properly preserved by the parties. Here, the respondents did not assert a constitutional challenge on the basis in the trial court and did not raise the issue in their appellate briefing at the Court of Appeals. Accordingly, on remand, the Court of Appeals should not address this constitutional issue. So ALJ 1 was available to the court when they drafted this opinion, and in this opinion, they still addressed the constitutional issues and cited the constitutional right to protect their children, which was also not preserved, which was also not cited in a brief. So I think that the Court of Appeals has had the ability and the knowledge of that, particularly in that remand instruction, and had that at the time that they did this case, and did not apply that to this case despite having known that and despite it being a direct requirement from this court. So turning back
one
again,
thing, do I have the timing right, that the Court of Appeals did not have ALJH 2?
they did not.
Which is really the one where, you know, we sort of brought the hammer down,
Mhm.
said you ignored us the first time, and
Correct.
so I do wonder a little bit if having now the court does have that guidance now, perhaps this is the test. If we were to remand, can you follow our precedent? And if not, it may cease to be our problem, to be judicial standards problem at that point.
Well, and what I will say is there have been several cases where, and not just AJLH, where this court has made those remand instructions, and then the court has come back again and said, even with that, we still think that we're correct, and really hasn't gleaned from the court's intent to apply a different analysis in those cases. So I would say that it would be appropriate, but obviously that is up to this court's decision. This Court of Appeals cannot freely substitute its conclusions for the trial court's conclusions of neglect. The majority cites that the testimony and records show no prior history of neglective abuse of EH or RH, and that's not required by this court. And the Court of Appeals then relies on that by looking at some cases in NG, AS, and particularly PM. And really, NG and AS really support what our position is if you read the opinions as a whole. And ironically, there was a dissent by the justice in those two cases who wrote the opinion in this case. And what the justice, or what the Court of Appeals majority is asking, is that you cherry pick out this one condition where it says, well, we need to have historical facts of the case, but in the circumstances in those cases, those were cases where there had been an abuse or neglect of an older sibling, and then there had been a period of time where in between the birth of a new child And so the analysis of that, and in those cases, and specifically in Ray JAM, which had the same types of circumstances, is you look to those historical facts in determining whether or not this new child is neglected and what's happened in the in-between. There are no historical facts in this case because this was a concurrent situation for both of these juveniles. And if you look at GC does say that you need to look at the current circumstances that present a risk. And these were current circumstances for RH. So there is no need to have a prior abuse. And I would ask that this court reject the premise that's made by the Court of Appeals for that. So accordingly, with RH also being of 10 years and being subject to the same parenting, supervision, and environment, he remains at risk of harm such that a neglect adjudication was sound, appropriate, and legally supported. Turning secondly to the applicability of privileges, the majority held that the burden remains with DSS, but they try to infer this confess or lose your child approach and want the trial court on a remand to view neglect within a lens focused on these privileges. And that is not required of this court. There is no burden shifting. I think DWP has already addressed that. These proceedings are not punitive, but are there to ensure the well-being of a child. The Court of Appeals intended to create at least an implication that silence on part of the parent in explaining the injuries could not be used against them. However, it's not the confession or non-confession. Looking at LH, it's the acknowledgement of those injuries. In the other case, in LH, I believe they acknowledged what it was, but there was still neglect on behalf of those other juveniles, but it was the acknowledgement that it was abuse and that they wouldn't do it again. And that is the same situation that we have here. The issue was not preserved or argued. Rule 10 of the Rules of Appellate Procedure do not allow for arguments before the court if it's not been properly preserved. It was not argued at the trial level. The issue was not likewise not argued in the parties' briefs, and the appellate courts do not make the arguments for the appellants. Case law establishes that constitutional issues that are not preserved are not appropriate for appeal. The court may not sua sponte raise these constitutional issues. The existence of a constitutional protection does not obviate the requirement that the arguments rooted in the Constitution be preserved for appellate review, and our appellate courts have consistently found that unpreserved constitutional arguments are waived on appeal. I will say, if you look at the brief from the other side, it appears as if what they're saying is that that's not what the intent of the court was. I would state that that at least is in some form a concession on their behalf, that that's not the right standard to apply and should not be applied. Again, even the issue of constitutionally protected status as a parent is not excluded from this requirement, as was stated in footnote 2 in AJLH 1. In addition, the plain language of the statute forbids the use of privileges other than the attorney-client privilege. No privilege in 7B310 shall be grounds for excluding evidence of abuse, neglect, or dependency in any judicial proceeding in which a juvenile's abuse, neglect, or dependency is an issue. That is what the public policy is. That is what the legislature intended. That is what makes the protection of the child more important in this situation. And I would contrast that between 7B and 7A. In 1999, July 1st is when it happened, 1999, the Juvenile Code was completely rewritten from Chapter 7A and placed into Chapter 7B. And the dissent does talk about, and note, In re Pittman, and In re Pittman has a discussion that 7A 631, prior to those statutes being intentionally changed by the legislature, did require trial courts to look at it with a lens of protection against self-incrimination in its analysis for abuse and neglect. So that was specifically not carried over to 7B. So the public policy and the intent of the legislature was not to allow that. So not only did they not carry that over, they specifically said in 7B 310 that there's no grounds. The evidence code 8-57.1 indicates husband and wife privilege shall not be ground for excluding evidence. The dissent does notice a TPR statute 1109. I will concede that that does apply to termination of parental rights hearings. However, it also talks about the husband and wife privilege. So what that does show is the clear intent for the public policy that these types of privileges cannot be held in higher regard than the protection of our children. Silence can be used in determining, and the court has held previously that silence can be used and a negative inference in civil cases can be applied. There's also the concern with regard in re Evans not being supportive of what the court intended or quoted it to be. There is a quote, confess or lose your children, and it's cited to In re Evans, which is a 1986 case prior to the statute changing. That quote does not appear in that case, nor does it appear in our record. And In re Evans doesn't address support or support any privilege regarding confession or spousal privilege. Those were not issues in that case. So this case doesn't have any facts that require an analysis of Fifth Amendment privilege. And I would say that the Court of Appeals cannot sui sponte create constitutional issues not properly preserved, and it's in the public interest that this court be explicit in the rejection of the Court of Appeals' position of applicability of constitutional issues in this context. If there's no other questions, I would reserve the remainder for rebuttal.
Thank you, counsel. We'll hear from the Appellee.
Good morning, Mr. Chief Justice and Associate Justices. My name is Melissa Gott. I'm from New Hanover County, and I'm here with co-counsel Christian Jones. I will be reserving approximately 10 minutes of my time. That way he can address some issues, and then trial counsel Mr. Brian Smith. Thank you for the opportunity to address you today. I think the primary conflation here is that we are looking at findings of fact that were not used to adjudicate RH neglected. The Court of Appeals in this case was correct in finding that RH was not neglected because at the adjudication hearing, DSS had to prove by clear and convincing evidence that RH was neglected. During the adjudicatory hearing, the burden is on DSS to prove the neglect of the child, and there is a presumption of parental fitness. North Carolina is clear that at the adjudicatory setting, hearings are limited to the items that are contained in the petition. So we must look to that when determining whether or not RH was neglected. Post-petition conduct cannot be considered at the adjudicatory stage. The adjudication, again, in Powers v. Powers, must be strictly based upon the items alleged in the petition. After the adjudication, there is a disposition hearing. In this particular case, there was an adjudicatory hearing and a disposition hearing held at the same time. Unfortunately, then, we have a conflation of two different standards and two different findings of fact. In this case, at the adjudicatory hearing, DSS failed to meet its burden of proof, and thus we should have never gotten to the disposition hearing on RH. If we look at the findings of fact, and our friends have mentioned several of those findings of fact, I would like to direct your attention to the finding of fact that actually adjudicated the neglect of RH. If we look at the trial court's order, finding of fact number 80, the trial court found RH neglected and stated, the juvenile RH is a neglected juvenile as that term is defined in North Carolina General Statute 7B 101 sub 15. In that he does not receive proper care and supervision from his parents and lived in an environment injurious to his welfare, as detailed in findings of fact 2 through 44 above. Thus, we must look at the findings of fact of 2 through 44 above to determine whether or not there were sufficient findings of fact to support the conclusion of law that RH was neglected. If we review findings of fact 2 through 44, RH is only mentioned a couple of times. For example, in finding of fact number 3, RH's name is referenced and his date of birth. Finding of fact 25, it mentions that RH was around EH. In 26, it mentions that the social worker met with the father and RH was present in the home. This is again reiterated in finding of fact number 28. Number 27 does mention postpartum, as our friends have pointed out, but that was postpartum when RH was born. There was no postpartum when EH was born. Number 31 mentions that a petition was filed alleging RH to be neglected. And then finally, number 39 mentions RH again, that the family had denied a history of broken bones and that RH had not had any broken bones. Those are the only findings of fact that mention RH in findings of fact 2 through 44.
Could we infer that what the court meant by that is, I'm going to tell you about EH, because then in 71, I'm going to make the finding that everything that happened to EH, I'm going to attribute as also being an injurious environment for RH, because there's no indication that the parents are going to take responsibility or assure DSS that something like this could not happen to a child again. And RH is of a tender age, I guess, meaning pretty close in age, still a very young child. And that was the logic of the court. Can we infer that?
I don't think you can infer that, because in this particular case, in order to establish neglect, we have to show that RH's basic needs were not being met. In this case, there are no findings of fact. And as Your Honor pointed out in findings of fact 71 and 72, that is referring to post-petition conduct, not pre-petition conduct. It's only pre-petition conduct that can be considered at the adjudicatory stage. And that's where we're at right now. So there was no clear and convincing evidence at the adjudication hearing as to the denial of the abuse. In fact, in 71 and 72, the court specifically says that it is the continuation of the parents to maintain that they are not responsible. That's what the court was stating in 71 and 72, that it was those post-petition denials that led the court to find, in this case, I contend that 71 and 72 were dispositional findings, contend that those do not establish that there was enough at the adjudicatory stage to establish neglect. So again, if we look at the trial court finding of fact number 80, it says that they only relied on findings of fact 2 through 44. 2 through 44, as Justice Deese pointed out, do address EH, but do not make any specific findings of fact as to the welfare and neglect to RH.
How do you distinguish this case from In Re JM? That was a case where there were life-threatening injuries inflicted on the younger of two children, both children being of tender age.
Thank you, Your Honor, for the question. That case was actually at the disposition phase, so that was past the adjudicatory stage. So the underlying neglect there had already been determined and stipulated to, so this case was at the disposition phase. So I would contend that In Re JM does not apply to these facts because we're at the adjudicatory stage, not at the dispositional stage. So looking back at findings of fact 71 and 72, 71 and 72, after the adjudication of neglect, the court does mention that the parents do not provide any plausible explanation for the injuries, and that it is an injurious household based upon the fact that the parents will not confess to injuries. Here, the trial court pointed out two factors in its determination that RH was neglected. First of all, an unsafe home environment, and second of all, the unconfessed injuries to EH. So let's look at both of those factors that the trial court outlined there. First, abuse inside the home is relevant, but is not sufficient in order to establish neglect. A finding of prior abuse standing alone is not sufficient in order to establish neglect of RH. There must be some specific fact that connects to RH, especially without any evidence in the record that RH was even present when these alleged actions took place against EH, and RH didn't even know about these actions that took place with EH.
What would be your argument against us reading finding of fact 28 and the delay in taking EH to get medical care as a separate factor other than the abuse? Is when your kid is injured, you don't take them promptly for emergency care. I mean, that's within the 2 to 44 that the court referenced as applicable to RH as well.
Yes, I certainly understand that perspective. From the time that the child was injured on the diaper changing table to going to Walmart, the child did not show any signs of fussiness no redness, no discomfort. The child was eating. The child was around other family members. The record shows that the family was operating as normal. The baby was acting as normal. And it was only until later on that evening that the father noticed that the arm wasn't moving normally, and out of concern, as any concerned parent would do, they decided to go to the ER. It was mentioned that the father didn't go to the ER. Well, there's a logical explanation for that as well. He stayed at home with the 4-year-old. That way the 4-year-old didn't have to go to the hospital. The grandfather went to the hospital with the mother and was communicating back and forth with the father to update the father as to the baby's condition. Additionally, there were no other factors cited by the court to suggest that neglect or abuse of RH would be repeated. The Court of Appeals properly determined that the trial court failed to identify any other factors. If you read through the findings of fact, the trial court listed the parent's failure to take accountability for EH's injuries, but failure to confess is not another factor under our case law. If we look at our case law, for example, in Ray JCB, that was overturned a neglect adjudication because despite the presence of the children, other children in the household, the alleged sexual abuse did not occur to the other children in the household, and the other children weren't even aware of the sexual abuse of the one child. In Ray JR held that sexual abuse of the daughter didn't mean that there was any sort of harm or neglect to the son. In Ray AJLH is distinguishable. In that particular case, the parents failed to concede that beating a child for weeks and months on end, making the child sleep on the floor, and putting them in the corner in and of itself was abuse. The parents thought in that particular case that those acts were appropriate for parents to do for discipline. That's where the court found that unconfessed injuries in that particular case rose to the level that you could determine that the child, or that it rose to the level of another factor. But again, that's distinguishable. We do not have that in this particular case. The Court of Appeals correctly found that the absence of a parental confession does not rise to the level of other factors either. To overcome the parental presumption of fitness, the other factor must indicate past harm or specific ongoing risk to the child in the household. There was no particular ongoing risk to the child in the household. This was a 4-year-old who never had any problems. This was an intact family that had never had any problems, no allegations of substance abuse or anything like that. The Court of Appeals was very clear in their assessment of the trial court and stated the transcripts and record appear devoid of any clear and convincing evidence of neglect of RH, other than the ipso facto application of non-confessed and unexplained injuries to EH. However, despite there being no clear and convincing evidence as to RH's neglect, the trial court went ahead to a dispositional hearing. The trial court effectively demands that the parents confess to abusing EH to establish that they can parent RH. DSS is arguing in effect, that we create an irrebuttable presumption that denial of abuse of one child is indicative of abuse of another. Adopting such a legal presumption operates, as the Court of Appeals pointed out, confess or lose your children. The Court of Appeals decision does not invoke the Fifth Amendment or the marital privilege. These are just red herrings. The Court of Appeals found that the trial court improperly relied upon the injuries of EH to override the standard and presumption of parental fitness. The presumption remains intact unless DSS provides clear and convincing evidence at the adjudicatory stage. This court has found that the integrity of the family unit must be protected by due process and the equal protection clauses of the 9th and 14th Amendments.
So if we accept your position, which is this was not the court, the majority was not saying we're applying a bunch of Fifth Amendment privilege or marital privilege here. It was really making the point that you're trying to put these parents in the impossible situation of saying confess to some crime or what have you, or we're going to use the fact that there's no explanation to take your children. it seems to me though, isn't what's really going on sort of the opposite, which is when a child is severely injured in the care of their parents, without some plausible explanation of how it happened, the court can say, well, then this is an injurious living environment because we expect parents to at least be able to have enough supervision over their children that they can explain what would happen if one of their children is severely injured. So just the total inability to have any explanation of what happened here is the thing the court's relying on to say it's an injurious environment. And then if you have another child of a similar age, you can attribute it there in a way that perhaps you couldn't if RH was much, much older at the time. So what's wrong with that if we just think that's what the law is, with following AJLH in these other cases?
Well, in this particular case, there were no findings of fact that there was harm or future harm for RH. It's just a generalization after the findings of fact 2 through 44. So in this particular case, the court didn't make any findings of fact as to the potential harm or the risk to RH. And so we would be in a different position if there were those findings of fact, but there aren't any in this. And that's what the Court of Appeals was pointing out, is that at the adjudication stage, the petition failed to rise to the level of clear and convincing evidence to establish neglect of RH. Additionally, our statutes provide due process rights to parents at the adjudicatory hearing. Contrary to the framing, the Court of Appeals does not invoke the parent's Fifth Amendment or marital privilege. We didn't assert that at the trial level. We didn't assert that in our briefs. We didn't argue that. The majority does not assert that the parents are shielded by the Fifth Amendment or marital privilege. Rather, the Court of Appeals is affirming that DSS has a very high burden to overcome the parental presumption of fitness by clear and convincing evidence. For the foregoing reasons, we respectfully request that this court affirm the Court of Appeals, and I welcome any questions.
Thank you, Mr. Chief Justice, and may it please the court. My name is Christian Jones of the New Hanover County Bar on behalf of the appellees. So I'd like to go back and talk about the distinction between the evidence required at the adjudicatory stage versus the dispositional phase, because I do believe that they're conflated in the cases cited and relied upon by the department. First, the trial court holds an adjudicatory hearing to determine if the child is abused, neglected, or dependent. And at that stage, there's a heightened requirement in place to protect the rights of the juvenile's parents and assure due process of law. The trial court can find a child abused, neglected, or dependent only if that status is proven by clear and convincing evidence. If the trial court does find at adjudication that a juvenile is abused, neglected, or dependent, then the court moves to the disposition hearing. At this stage, the trial court determines the child's placement based upon the best interest of the child. So in other words, it is not until after abuse, neglect, or dependency are proven by clear and convincing evidence that the best interest of the child test is implicated. So I'd like to highlight a number of cases that the department has referred to today and refers to in their briefs, and show that unconfessed injuries are dispositional factors rather than factors to be considered at adjudication. Specifically, these factors should be only considered after the constitutional rights of the parents have been pierced and when the best interest of the child test is implicated, not for the underlying adjudication. So first, DSS provides a number of cases that deal with the initial adjudication. However, in all of the cases relied upon by the department, there were additional factors beyond the unconfessed injuries which were required to support the adjudication of neglect. The first case I'd like to refer your honors to is In Re JAM, where this court upheld a neglect adjudication, but in that specific case, while there were unconfessed injuries, there's also a death in the home, there's prior significant DSS involvement, there was a history of domestic violence with the prior 6 children, and there were prior TPRs. Also, there was evidence that the prior children had witnessed domestic violence or were caught in the middle of the altercations. The other case, cited by my colleague and by the department, is In re AJLH. Again, in that case, the parents had made affirmative statements towards indicating that they were going to continue or believed that the behavior that they were engaging in was the appropriate way to discipline a child. Specifically, there would be predictive value in that on a future likelihood of harm to those other children in those instances. Another case relied upon at the adjudicatory stage was In re AW, where this court upheld a neglect adjudication when another child had, in addition to the unconfessed injuries, died in the home, when mom was abusing prescription drugs, and when the mother allowed a heroin addict to live in her home. What all these cases have in common is that additional factors beyond abuse in the home and non-confessed injuries were required to uphold a neglect adjudication because these factors were all predictive of future harm of the children. Substance abuse is indicative of future harm or the potential for future harm of the other children in the home. Domestic violence, ongoing domestic violence, repeated involvement with DSS. Those all suggest a future risk to the other children. To bolster this point, I'd like to address In re AS, which was cited by the majority opinion in this case and referred to by the department. In that case, the majority upheld a neglect adjudication with non-confessed injuries, but the North Carolina Court of Appeals explicitly stated that the mother's response to the abuse was not the basis for the adjudication. In that case, the Court of Appeals was distancing themselves from predicating a neglect adjudication based upon unconfessed injuries. The remaining cases, which seem to be more on point, or DSS argues are more on point with their arguments, all come from the dispositional phase of either a neglect adjudication or a termination of parental rights. While these cases do apply the clear and convincing evidence standard, these cases are an opposite because at the stage of the case, the best interest of the child standard was at play. So the first case I'd like to address is In re DWP, which is relied upon by the dissenting opinion in this case and by the department, which upheld a termination of parental rights, but the underlying adjudication of neglect was already stipulated to by mother and not challenged on appeal. And there were other factors supporting mom's lack of progress. So in that case, the mother had already stipulated the court was not considering whether it was sufficient for adjudication. The court was only considering whether or not mother had made progress towards her plan, remedial measures after the filing of the petition, which the court can impose upon the mother.
Do you think the standard is higher for a TPR or for an adjudication of neglect?
I believe both apply the clear and convincing evidence standard, Your Honor, but I believe at disposition, the court can consider the best interest of the child standard rather than the heightened constitutional standards articulated in the Troxel v. Granville case by the United States Supreme Court.
You understand that a termination of parental rights terminates parental rights.
That's correct, Your Honor.
A neglect adjudication does not terminate parental rights.
Yes, Your Honor. And just to respond to that a little further, Your Honor, the point that I'm trying to make with these cases is that the terminating event for the termination of parental rights was already stipulated to at that point. So it was in re DWP, the underlying adjudication, which could be the terminating event, had already been stipulated to by the mother and was not the issue that was being decided at that point. I would argue that the department cites these cases just to asking this court to consider whether unconfessed injuries support an adjudication of neglect. However, when applying the heightened requirements and not the best interest of the child standard, the required in an adjudicatory hearing, I believe unconfessed injuries are not sufficient as another factor to support an adjudication of neglect for the reasons articulated by my colleague that I believe it is shifting the burden to parents to come forward and provide affirmative proof of their fitness to parent their children when they've already have a constitutional presumption that they're able to do so. And for the foregoing reasons, we're asking the court to affirm the Court of Appeals opinion. Thank you, and I am happy to answer any questions.
Thank you, counsel. Rebuttal.
Mr. Chief Justice and Associate Justices of the Supreme Court, I want to have limited time. I'm going to make a couple of points. Going to Justice Allen's question about, what this court should do, should it decide in favor of the petitioners. I think when you look at the case of AJLH, I think it's instructive because it showed what this court does when there's a parent on the behalf of the Court of Appeals to not follow this court's precedent. These cases regarding these same facts have been decided by this case since, I think it was JAM in 2019. Some of the judges on the Court of Appeals panel was involved in these very cases with this very law, and the Court of Appeals did not cite to a single source, guiding source in this case. So I believe it would be appropriate to bypass and remand directly to the trial court. Going to Justice Dietz' question about the age of the children being reversed, I think that that's something we could get into if there was an explanation offered by the parents. So, for example, if the parent said, "This is why we did this because it was postpartum, because it was a young child, there was a lot of crying at night, these different things," then the court could make a distinction and say, well, the older child is not at risk the same way the younger child was. But that goes into the very play of what we have at issue in this case. The non-confess, the failure to acknowledge what happened and the failure to acknowledge that something bad happened and it was a non-accidental injury is the very reason the court couldn't make that distinction and say, well, the older child, RH, is not at risk of the same injury as EH, because we don't know why the parents did what they did.
So it seems to me, what's your response to the strongest argument your friend has is that in the description of EH's injuries, there's an observation, a factual observation that the parents just say the only thing that happened was the pop during the diaper change. We're not aware of anything else that happened to the child. And it's not until, I think it's finding fact 71, where the court then kind of fleshes that out and says the parents have not taken accountability. They've offered no plausible explanation of how it could happen, and that's the injurious environment. But your friend says the beginning of that finding of fact makes clear that it's referencing post-petition evidence because it's talking about a time frame that came after. So what's your response to that? Can we still look to that, or do we even need that given what's earlier in the findings?
Both, Your Honor. So first of all, the idea that this confession can only be used in certain stages, this has been used by this court in the adjudication stage, in the permanency planning stages, and in TPR termination stages. So it's been used by this court throughout, and you wouldn't get to any of the other stages unless you first established it by the adjudication stage. So I believe that it can be used by the court throughout, and that evidence did exist at the time required. I think, in essence, there's no way to get around this court's precedent on this issue. To rule in favor of the respondent parents would require this court to overturn all this other precedent. And the idea that the non-confessed or failure to acknowledge injuries is not sufficient is just not true. In this court's opinion, in the first AJLH case, I quote, the court said, "The key other factor in this case, beyond the abuse of Margaret, is the respondent's inability to recognize it was abuse and their corresponding inability to commit to never repeating it." So this inability to remedy the situation, to acknowledge, I mean, at least they acknowledged the behavior and thought it wasn't inappropriate. Here, we don't even have an acknowledgement that the behavior happened, although that's been a finding by the court. The abuse has stood even by the Court of Appeals. So here we have a failure to even recognize by the parents that anything happened, they did anything wrong. And that's been consistent throughout ALJH, JAM, where it's the court said it can be used as weight, and the failure of knowledge was specifically, and the consistency with both parents being in the home as a factor. So
Thank you, counsel.
thank you, Your Honor.